Okay, good evening. We are in our week 3 and week 4. Last meeting, we discussed the different constitutional provision of labor as well as the basic precepts of PD 442 or the Labor Code. So for this meeting, we would be discussing Unit 2, which is human and environmental factors in labor. Okay. At the end of this unit, the students are expected to compare and contrast the unfair labor practices committed by employer and employee, differentiate the duties of workers and employers, deconstruct the need for a union and the morality of strike, integrate the consequence of an illegal strike and an illegal lockout, analyze the necessity of a safe working environment, attributing certain governmental policies, integrate the role of employers towards a more progressive and sustainable employee satisfaction, structure the different disciplinary actions that might be undertaken, and develop and validate an employee's evaluation program. One of the natural inclination of man is to form or join or assist any organizations. This tendency is recognized by the very fact that upon birth, we are already a member of a unit. In its formative stage, human beings tend to excite himself or herself every time he or she would go to a park or just simply band with his or her siblings or any relative. During his education, his desire to associate with friends, be it formal or informal, at times will decide or determine how he reacts in life. In his employment, the individual, now an employee, also would like to penetrate in the more formal aspect of joining an organization. This chapter will discuss labor organizations as a tool to inform, redress, and claim rights as mandated by legislation. To fully realize the purpose of this chapter, questions are posed to clarify certain issues. To wit, how does a labor organization protect the right of employees? Why do employees join a union? Why is a safe working condition important in labor? How should the employer implement safety programs for the employees? Why is human factor important in employment? How should the employer discern to employees' problems? How should the employer evaluate his employees? How do appraisers commit error in appraising? Okay, so again, as discussed last time, we have some working assessment, and for this unit, this would be your working assessment. You would be asked to watch a video clipping and make a thought paper. A thought paper is a perception or one's personal view regarding of any condition or issue at hand. In your case, after watching this link, you will be making a thought paper on your perceptions regarding the topic, an introduction to labor history. Okay. So I presume that after watching the initial link, you already have an idea of what a labor organization is all about, but let us have some discussions for you to have an in-depth view of our topic. Okay, so what is a labor organization? So this is the first question posed. Kailangan muna natin malaman kung ano ba yung ibig sabihin ng isang labor organization or a labor group. A labor organization is any union or association of employees in the private sector which exists in whole or in part for the purpose of collective bargaining or of dealing with employers concerning terms and conditions of employment. Labor organizations, unionism, labor associations, or whatever it's called, is a product of centuries of suffering by laborers from their employers. The relationship prior the dawning of a more legal and humane treatment is that of a master-servant approach. If we would go back in time, even during the days of the pyramid, we could conceptualize the master whipping the servant slaves for them to build temples, for them to build pyramids, or any infrastructure for that matter. Although this concept is somewhat obsolete in our day, yung mga tinatrato bilang slaves or servant, they are not paid. Mind you, they are not paid. Hindi sila binabayaran. Kundi this became a part of the burden for them being a person with no right at all. So yun ang concept dati. Yun ang nakikita doon sa kung paano tinatrato ng mga masters yung kanilang mga slaves. A painful review of labor literature worldwide became the rule instead of the exemption. Even before the Industrial Revolution, laborers are more so often treated as merely slaves of the pre-industrial masters and therefore subjected to oppressed term. It is not uncommon that issues of maltreatment, unpaid salaries, and inhuman acts were very evident during those days. Now going back to our definition of what a labor organization is. This is a more concise definition. The word private sector should not be a cause of confusion. Sana kayong malito na ang pinapayagan lang na magkaroon, sumama sa labor organization ay mga empleyado ng private sector, ng sektor na pribado. So that's wrong. Even employees in the government are allowed to join a labor organization, a labor union, or a group. So hindi bawal sa mga empleyado ng gobyerno ang sumama, makiisa sa isang labor organization. Although, with regard to certain privileges, merong mga bagay na hindi inaalaw sa mga empleyado ng gobyerno. Take for instance the right to strike in accordance with law. So, ang karapatan na sumama sa isang strike ay hindi po ibinibigay sa empleyado ng gobyerno. Why? Particularly if the task or the work that one should perform is more on to save lives, national security, for example, and very vital in the operation of the government. Sandali lang, hindi ka pwede sumama sa strike. Well, so just imagine, what will happen if a doctor, isang doktor, is allowed to join a strike. And during that time, mayroon siyang pasyente inoperahan. So ano na lang yung sabihin sa pasyente na inoperahan niya? Brad, sandali lang. Mag-i-strike muna ako sa labas. Diyan ko muna, hintayin mo ako ha. So, kawawa naman yung pasyente. Ano? So, isa ito sa mga halimbawa o mga rason kung bakit hindi pinapahintulutan yung mga empleyado ng gobyerno, primarily kapag ang trabaho mo ay vital to save lives, to promote peace, national security, ay hindi ka pwede sumama sa strike. Yes, you are allowed to join a labor union, a labor organization, a labor association, but not the right to strike. Okay, we mentioned a while ago the word industrial revolution. We have 4 phases of industrial revolution. By the way, kapag sinabing revolution, do not instantly have the idea na kailangan mag-alsa or umaklas. No. In our discussion, kapag sinabi natin industrial revolution, ito yung stages, phases ng pagtatrabaho sa atin, worldwide. Hindi lang sa Pilipinas, worldwide. We have 4 stages. We have the first industrial revolution or the steam revolution, the second industrial revolution or the mechanical revolution, the third industrial revolution or digital or computerization, and last, the fourth industrial revolution or artificial intelligence. Now, if we would go back in time para malaman kung ano pa yung phases ng revolution na yan. Yung steam revolution, ito yung paggamit ng steam, paggamit ng coal para umandar yung iba't ibang mga bagay. Katulad ng limbawa ng tren na ginagamitan ng coal para umandar at ganoon din yung mga steamboat. So steam ang nagpapagana sa kanila. A source of energy. Pagkatapos noon, we have this mechanical stage or mechanical phase. Kapag sinabi mechanical phase, ito na yung may mekanismo. Katulad ng paggawa ng automobile, for example. Okay? Yung unang pahina ng mga factories natin. So dito pumapasok yung mechanical phase or mechanical stage. After that, digital or computerization. The use of computers. The use of technology. And sa ngayon, worldwide, we are under the 4th phase or the 4th industrial revolution or the use of artificial intelligence, mga robot or use of robotics. Dito sa Pilipinas, we already have some establishments that uses robot as a mean of starting a business. For example, we have this one fast food chain in NCR wherein siya yung kumukuha ng orders and nag-accept din ng payments. So, simula na ito. But in other countries, hindi lang sila nasa ganung phase, kundi they are more than just yung nasa front desk. Yung mga robots na nila, yung actual na gumagawa ng operation ng negosyo, ng mismo trabaho. So those are the 4 phases of industrial revolution. Again, we have some jurisprudence, with regard to the right to self-organization. In the case of Reyes versus Trajano, the Supreme Court held that the right of self-organization includes the right to organize, the right to affiliate with a labor union, or to determine which of 2 or more unions in an establishment to join. So kung ang isang empleyado, pagpasok niya sa isang trabaho, pagpasok sa isang establishment, there are 2 labor organizations na nandun, karapatan niya ang pumili na kahit na saan doon. Okay? Either si organization A or organization B. And nobody can prohibit him from joining one. Walang pwedeng magpuwersa sa kanya na sumama kay organization B or organization A for that matter. Now, let us continue. And to engage in concerted activities with co-workers with the purposes of collective bargaining through representatives of of their own choosing or for mutual aid and protection. So, again, let us look back at the purpose of why one should join a labor organization or labor group. Actually, later in some slides, we will be discussing the reasons why an employee would join a union or labor organization. So basically, the main purpose is for collective bargaining. To get the sentiment, kunin ang sentimiento ng mga employee at yung sentimiento nyo na iparating sa kinaukulan, which is the management side or the manager. So yun ultimately, yung purpose ng pagsama sa isang self-organization or pagbuo ng isang labor union. Also, logically, the right not to join, to affiliate or assist any union or to disaffiliate or resign from a labor organization is subsumed or presumed with the aforementioned right. Kung ikaw, in your own will, kagustuhan mo na umalis or wag sumama, that is included in the right to join a labor organization. Kasama rin yun. It is implied na the right to join also include the right not to join a labor group or labor organization. Now, who may join, form, assist a labor organization? Sino ba yung pwede sumama? Sino ba yung pwedeng makiisa sa isang labor union or labor group? So what does the law say? Article 243 of PD 442 or the Labor Code provides that all persons employed in commercial, industrial, and agricultural enterprise and in religious, charitable, medical, educational institutions, whether operating for profit or not, shall have the right to self-organization. Okay. From that provision alone, masyadong klaro, it's very clear, na lahat ng tao ay pwedeng sumama, pwedeng lumaho, the right to join, to form a labor group or labor organization. Whether it is for profit, may kita man, o walang kita, they are allowed to do so. The important thing here is the other statement which provides that it should be of their own choosing. Dapat pinili nila, hindi pinwera sa kanila. Okay, hindi ipinilit na sila ay dapat sumama sa ganito or sumama sa kung ano man labor organization. Willful dapat. Okay? Walang vitiated consent. Walang force, walang coercion, walang intimidation. Dapat gusto niya. Ambulant or those without definite employer may form labor organizations for their mutual aid and protection. Ano ibig sabihin nito? Kapag sinabi natin ambulant laborer, ambulant worker, sila po yung walang definite employer. Katulad nino, si mamang magtataho, si mamang sorbetero, mamang mag-fishball, yung mga nagtitinda sa palengke, sila yung sinasabing ambulant worker, ambulant vendor. Okay, so may they join or form a labor group? So, ang sabi dito, yung mga walang definite employer, pwede sila magbuo as long as their intention is for their own aid and protection. So here, sinabi dito, kung sino ba yung mga ambulant workers? Ambulant workers are workers without definite employers such as street vendors, online business. Kung naalala ninyo, this pandemic, medyo nagkaroon ng paghinto doon sa mga nagtitinda sa lansangan, particularly because mas binibigyan pansin yung kaligtasan ng mga tao during those time, lalo na nung lockdown. Kaya nag-mushroom na sprout yung mga online business. Di ba? kaliwat kanan yung mga naging online businesses. And true to it, madami ang nag-isip na magpalit ng line of business dahil mas nakita nila na mas maganda yung kapag nasa online sila. Ang magiging problema lang nila yung supplier, yung delivery, pero not as big na problema katulad na ikaw ay nagtitinda sa palengke during pandemic. Okay. So they may nevertheless form a group for their own protection and aid too. Okay, the labor code renounces any form of coercion, restraint in the part of the employer. Bawal daw na pilitin, bawal na puwersahin ni employer si employee sa pagsama sa kahit na anong labor organization. Ano? Going back to our discussion, kailangan it should be his own choosing. Sarili niyang pinili. In the part of the employer in prohibiting its employees in furthering their rights to self-organization. It is stated that it shall be unlawful for any person to restrain, to coerce, discriminate against, or unduly interfere with employees and workers in their exercise for their right to self-organization. So very clear yan. Ano, nasa batas yan eh. Article 246, PD 442. So if your employer, for example, would say na, sandali, bawal dito ang labor organization. Bawal dito ang union. Or we do not allow a union dito sa opisina. Pwede sabihin na, sandali po, under the law, hindi po pwede ipagbawal yan. Okay. However, there are exceptions. There are certain line of work which because of the very nature of the work, hindi po pwedeng magbuo or sumama sa isang labor group. So, who are they? So, we have employees of international organization, armed forces of the Philippines, police officers, policemen, firemen, jail guards, managerial employees, confidential employees, employees of cooperatives who at the same time are its members, and aliens without a valid working permit via the principle of reciprocity. So, sila yung mga empleyado, sila yung mga tao, mga individuals na hindi pwedeng magbuo ng grupo. Eh sir, bakit po? Nakakala ko ba, sabi kanina, nung batas natin, o labor code, na all persons are allowed. Remind you guys, kung titignan natin one by one itong mga employees na ito, there is this compelling reason kung bakit hindi sila pwedeng sumama o magbuo ng isang labor group. Okay, Armed Forces of the Philippines, for example, or policemen, for example, okay, what do they have na pwedeng mag-cause ng fear sa mga tao? Ano? Of course, weapons, baril, diba? Armament. So just imagine, the armed forces, policemen, nasa daan sila, nagrarally sila, holding their firearms. Maaaring magkaroon ng chaos, disorder, andyan yung public safety, national security. So madaming concern. Diba? Kaya hindi sila pwede sumama sa kahit na anong labor group. What about managerial employees? Si management, sila po yung nag-formulate ng policies. Okay? Since sila yung nag-formulate ng policies, human nature would dictate na yung policies na gagawin mo should be favorable sa iyo. Because no person would do a thing na sa simula-simula pa lang harmful sa kanya. Therefore, lahat ng mga gagawin ni management ay favorable sa kanya. Kaya nga, ang sabi ng batas natin, sabi ng constitution natin, yung mga laborers now are given the opportunity to have a dialogue with management to come up with a company policy. Dahil simula pa lang si management kapag gumawa ng policy yan, beneficial sa kanila. So dito pumapasok yung mga labor group. They would give their sentiment through a dialogue. Sabihin nila na, boss, that would be unfair for us. Okay? Unjust para sa amin yan. So kailangan mag-meet sila halfway para magkaroon ng win-win solution. What about confidential employees? From the word confidential employees, they have confidential papers, confidential documents na pwede nilang gamitin against whom? Against the management. Diba? So, if they are allowed to form a group at hawak nila yon, pwede nila sabihin kay management, we will reveal the documents that we have kung hindi nyo kami papayagan sa kagustuhan namin. Therefore, yung pressure na yon mabigat kay management na magiging paraan ito na magkakaroon ng leash si management sa liig niya at sumunod na lang sa kagustuhan ni confidential employee. Kaya nga bawal silang sumama at magbuo ng kanilang labor group. Okay. Bakit nga ba? Bakit nga ba sila, o bakit nga ba nila gustong sumama sa isang labor union? So, these are the reasons, Mondi 2012 enumerated the reasons or major reasons why people or employees would like to join a union or a group. Dissatisfaction with management, a social outlet, opportunity for leadership, forced unionization, and peer pressure. Okay, kapag sinabing dissatisfaction with management, if you are dissatisfied with management, your tendency is to look for a group na tutulong sa iyo para ma-elevate yung grievances mo kay management. The principle of the word of many is greater than the word of one. So just imagine na isang tao hindi pinagbigyan. Okay? Magrarally siya all by himself. Nasa labas ng gate, may hawak na placard. As against a group of employees, nasa labas ng gate, may hawak ng placard, sino ang mas forceful sa kanila? Sino ang mas may puwersa sa kanila? Of course, yung mas madami as compared to one. Kaya kapag dissatisfied si employee, it would tempt him to join a union or organization. Another one is social outlet. Man is a political animal. Man is a social animal. Simula pa lang gusto na niyang sumama sa isang organization. Ayaw niyang maging outcast. Ayaw niyang i-ostracize siya ng mga tao. Kaya sasama siya sa lipunan, sasama siya sa labor organization in terms of employment. Opportunity for leadership. May hierarchy din yan may pagkakasunod-sunod din yan. May presidente ng union, vice-presidente, sekretaryo, tresurero, etc. etc. So, if you have in yourself the character of a leader, of course, gusto mo sumama sa isang labor group para ipakita mo yung galing mo rin. And then, forced unionization, kapag kailangan sumama, dahil if you are not one of us there, you are against us. So, yun yung ibang mindset, And of course, lastly, we have peer pressure. Yung mga colleague mo, they are members of different labor group. Ikaw naman, andun ka. So, gusto mo rin sumama sa kanila. To be with them, to be amongst them. Ano ba yung objective ng union? Number one, secure and if possible, improve the living standards and economic status of its members. So ito yung mga objective, yung nakaatang sa balikat ng labor group. Kailangan, what they should do is to improve living standard, to improve economic status of its members. Kaya nga merong collective bargaining. Makikipag-usap sila kay employer para iparating yung mga hinaing ng mga manggagawa. Mr. Employer, hindi na po sapat yung kinikita ng mga employee. Siguro it's about time na itaas ang sweldo. Katulad ng nangyayari ngayon, ano? There is this issue that the 13-month pay is or maybe withheld ng mga employer. Pwede daw hindi ibigay ng employer, particularly kapag distress daw. Kapag distress, kapag mayroong point of there is this possibility that this company will go bankrupt. Wala ng pera because of this pandemic. So, ang pwede magparating kay management sa hinaing o sentimiento ng manggagawa ay ang isang labor group or labor union. Okay? Actually, speaking of this 13-month pay under the law, it is mandatory. Ano? However, there are certain exceptions. Katulad niya kapag distress. The management or employer should first get a permission or should first be allowed by the government to be exempt from payment of 13-month pay. Yun yung unang option. Another option, i-defer yung pagbibigay ng 13-month pay. Defer means to postpone. Instead na, under the law kasi, on or before December 24, kailangan ibigay yung 13-month pay. So kapag sinabing defer, maaring in some later date sa ibang panahon. Pero wag naman sana after 10 years or 20 years, sobra naman yon. Eh wala nang pandemyo, tapos hindi pa rin ibibigay yung 13-month pay. That is cruel. Another option would be to meet halfway. So ano yung halfway na yun? Ibigay yung kalahati ng 13-month pay. Yung employee now should also be empathic with their employer. Dumaan din sa paghihirap si employer. Hindi lang po si employer ang naghihirap ngayong pandemic. Even the employers had hard time in coping up. So dapat magtulungan sila for them to meet halfway. So maaring 50-50. Ano? Ibigay yung kalahati kasi it's talaga mandatory. And then yung the rest, yun po yung maaring i-defer or by installment. Importante, magkasundo silang dalawa. Si employer at si employee. Hindi po pwede na isa lang ang mag-dictate nun. To enhance and if possible guarantee individual security against threat, contingencies that might result from market fluctuation, technological change, or management decisions. So, kailangan daw itong labor union nito, they are there for the purpose of guaranteeing the security ng employee. Ano? Security na hindi siya basta-basta bigla na lang matatanggal nang wala naman rason. There should be a reason kung bakit siya tatanggalin. To influence power relations in the social system in ways that favor and do not threaten union gains and goals. To advance the welfare of all who work for a living, whether union members or not, and to create mechanisms to guard against the use of arbitrary and capricious policies and practices in the workplace. So those are the union objectives. Now, ano ba yung duties ng worker? What is expected from them? To work honestly and comply with all the requirements, magtrabaho ng tapat. Okay? Sumunod sa polisiya. As long as it is legit, as long as it is legal. Next one, to never injure capital or steal from the employer. Huwag magnakaw. Okay? Huwag manira ng gamit. Huwag saktan si employer. From a basic principle na do not bite the hand that feeds you. Next one, never outrage the person of the employer. Huwag mong galitin si employer. Okay? Huwag mong galitin si employer. if you have any grievances sa kanya, pwede yung sabihin sa kanya in a manner naman na maganda yung paraan ng pag-iipag-usap nyo. Huwag yung puwersa ng pag-iipagbangga, no? Yung kasi yung problema nun eh. Kapag galit ang isang tao, and the other one is also angry, tendency magka-clash yung dalawa. Kailangan there should be a cooler intervention. Dito pumapasok yung union. Okay? Para mag-usap sila at maging maayos yung dialogo nila. Never employ deceit or violence presenting a cause. Huwag ka man loko. Huwag mong lokohin yung employer mo. Kung meron kang gusto iparating sa kanila, present your case. Okay? Do not use fraud in presenting your case. Kung ano yung sa palagay mo dapat ay ibigay sa'yo, i-present mo ng maayos. Never consort with agitators or men of evil principles. Okay? Kung meron ka problema with the management, huwag ka magpagatong. Huwag kang magpagamit sa mga taong simula pa lang, alam mo na masama na kaagad ang intensyon nila. Now, ano naman ang basic duties ni employer? A while ago, we discussed the duties of employees. Ano naman si employer naman? Number one, we have respect human dignity of workers, trato yung mga workers bilang tao. Okay, trato sila bilang tao. Respect begets respect. Kung paano mo gusto ikaw na tratuhin, ganoon mo tratuhin yung mga empleyado mo. Appreciate their work. Kapag may ginawa sila, very good. Yung mga bata na, yung mga nasa kinder, diba? Yung mga teacher nila, binibigyan sila ng star, and then yung mga bata pati sa bahay, tuwan-tuwa, may star po ako. Natuwa sa akin si teacher. So, yung moral nila, nabuboost. The same thing. Ganon din, hanggang sa maging employee ka rin. It would boost your moral. Kapag na-boost yung moral mo, yung productivity mo, tataas din. Okay? So, domino effect yan. Never treat them as slaves for making money. So, si employer naman, huwag naman puro pera ang iniisip. Okay? Remember si Mr. Krabs? If you are familiar with SpongeBob, okay, si Mr. Krabs, puro pera yan. Lahat ng mga bagay, kailangan pera ng pera. Okay, huwag tayo maging katulad ni Mr. Krabs. Okay, kailangan din natin, sa part-time employer, kailangan din, hindi pera ang katumbas ng mga tao. Not to look at people as money. Huwag silang tignan bilang pera. Okay? Human beings siya mga yan. May puso sila, may nararamdaman sila. And kung hindi natin sila itatrato ng tama, tendency in the long run, kapag nag-aklas yung mga yan, babalik din sa atin yung ginawa natin. Never assign them tasks beyond their strength. Dapat alam ni employer yung weaknesses and strength ni employee. Okay? Help them develop their strengths. Huwag gamitin yung weakness sa kanila. Kasi the moment na si employer would employ tactics, para lumabas yung weakness ni employee, it would redound back to him. Babalik sa kanya yon. Dahil magiging less productive. Hindi magagawa ni employee yung task na pinapagawa sa kanya. So, babalik din sa kanya yon. Give them commensurate wages. Yung katamtaman na sweldo. Yung alam ni employer na makakatulong sa kanila, makakabuhay sa kanila. Provide for their health and social recreation. Ito yung kalimitan, kadalasan, hindi nagagawa ni employer. Mag-provide ng atensyon sa kalusugan ng mga manggagawa. Mag-provide ng social recreation. Bonding din ito. Outside the family, dapat yung employment, family din ang trato nila sa isa't isa. Okay? Kasi kung familial or family ang trato nila sa isa't isa. Tendency, yung relationship nila, mas magiging maganda, mas magiging maginhawa. Now, going back, to provide for health, assistance, lalo na ngayon, pandemic, kailangan tignan din ni employer yung kalusugan ng manggagawa niya. Kapag mahina yung manggagawa niya, kapag sakitin yung manggagawa niya, again, it would go back to him. Absent yan. Kapag umabsent yan, matetenga yung trabaho niya. Less productive siya. Less sales din yun. Diba? Itrato nyo yung manggagawa, yung tao, kung paano nyo gusto nyo, itrato yung sarili ninyo. Provide them to practice religion. Another one, upon entering ni employee, bago siya mag-empleyado, dapat sabihin din niya kay employer na during this day po, ito po yung araw ng simba namin. During this day po, hindi po ako makakapasok dahil ito po yung araw according to our religious belief na dapat kami nasa bahay at nagpa-practice na religious faith namin. Dapat irespeto din ni employer yan. I-designate yung day na yon as rest day ni employee. Instruct them on how to use their money wisely. Hindi yung pagbigay ng pera, o yan, kayo na bahala dyan. Yan na yung napagtrabahuhan ninyo. No. Kailangan din maging financial literate yung mga tao. Through a financial education initiated by the employer. Instruct them to love their family. Yan. Kung paano mamahalin yung pamilya, ganun din ang pagmamahal sa trabaho. So, dapat nagpa-practice din o pinapractice din ni employer. Sinasabihan niya yung manggagawa niya, love your family. Okay, paano? Kapag araw ng sweldo, yung pera ninyo, dalhin niyo muna sa pamilya ninyo. Huwag yung gastusin sa pag-inom, huwag yung gastusin sa mga bisyo ninyo. Family first. Provide them with opportunities. Bigyan niyo sila ng oportunidad according to their qualification. Okay? Mag-provide ka ng seminars, mag-provide ka ng trainings para sa kanila, additional knowledge sa mga manggagawa. Bakit? Kasi magagamit nila ito sa trabaho nila. Kapag nagamit nila ito sa trabaho nila, then mas malaking opportunity sa inyo. So, we could sum up all of this, itong mga basic duties ng employer. Isa-sum up natin ito sa statement na kung paano nyo gustong itrato yung si employer, ganoon din dapat si employer pagtrato niya doon sa mga subordinates niya, sa mga manggagawa niya. Okay. Our next topic is unfair labor practices. From the word itself, kapag sinabi natin unfair labor practice, these are actions, illegal actions, illicit actions, that if committed, have consequences. Okay, may consequence ito kay employer or kay labor organization. Meron pong dalawang unfair labor practices or ULP. One is that committed by the employer and the other one is that committed by a labor organization. So simula tayo doon sa ULP committed by employer. So letter A, to interfere with, restrain, coerce employees in the exercise of their right to self-organization. Again, time and time again, parati natin binabanggit na hindi pwedeng pakialaman ni employer yung manggagawa niya sa kung saan gustong sumapi o sumamang labor union or labor organization yung manggagawa niya. To require as a condition of employment that a person or employee shall not join a labor organization or shall withdraw from one to which he belongs. So, ano yung kaibahan nito ni B? Kay A, kapag sinabing to require as a condition of employment, before being accepted in the employment, baka sabihin ni employer na, o kapag ikaw ay miyembro ng isang labor organization, umalis ka na. Or wag kang sumama sa kahit na anong labor organization. Kapag sumama ka, tanggal ka, dismiss. Kapag hindi ka umalis, tanggal ka. So ito po yung kaibahan ni letter B kay letter A. And this is known as a yellow dog contract. C. To contract out services or functions being performed by union members when such will interfere, restrain, or coerce employees in the exercise of their right to self-organization. Now, there may be instances wherein because the employer refused to bargain collectively or the employer performed illegal actions, magi-strike yung mga employees. So, maaring gawin ni employer para hindi niya maramdaman yung pressure ng pag-i-strike ng employee, ay kukuha siya ng ibang tao sa labas. Hindi niya empleyado. Okay, hindi niya empleyado, magko-contract out siya ng service sa labas. So, yung mga taong kinuha niya sa labas would be performing the duties of the employees who are on strike. So, if that is allowed, again, if that is allowed, then what will happen? Wala pong pressure kay employer kung mangyayari yan. Hindi niya mararamdaman yung strike. Patuloy pa rin yung operation ng kanyang negosyo dahil may nagtatrabaho naman o tumatrabaho doon sa naiwang trabaho ng mga strikers. Bawal po yan. Ang tawag po dyan ay scam. To initiate, dominate, assist, or otherwise interfere with the formation or administration of any labor organization, including the giving of financial or other support to it or its organizers or supporters. Si employer is also prohibited from having his own labor organization. Hindi siya pwedeng mag-create ng sarili niyang labor organization. Okay? Bakit? The moment itong labor organization na na-create niya, ang nanalo as bargaining representative, representing the entire employees, for sure, yung mga stipulation na ibabargain nitong labor organization na binuo niya is favorable kay employer kasi sa unang-una binuo niya yung labor group na yon. Para mas magkaroon kayo ng idea, labor organization A, labor organization B, labor organization C. Okay? Assume natin na there are 3 labor organizations. And one of them was formed or was created by the employer. Now, pagbobotohan lahat ng mga manggagawa, kung sino doon sa 3 labor organization ang magre-represent sa kanila para maging bargaining agent. Para kung sino man si bargaining agent, siya ang makikipag-usap kay employer para magkaroon ng isang collective bargaining agreement. Now, what if ang nanalo yung labor organization na binuo mismo ni employer? Sa palagay niyo ba, yung terms and condition na dadalhin nila kay employer ay lahat ng mga yon pro-employee? The mere fact na ang nagbigay ng financial support sa kanila, the mere fact na ang nagbuo sa kanila ay si employer, there is a doubt na pro-employee yung ine-negotiate na stipulation kay employer. So, ang tawag po doon ay company union. And again, this is prohibited. Next one, to discriminate in regards to wages, our support, and other terms and conditions of employment in order to encourage or discourage membership in any organization. Okay. Hindi po pwede na si labor organization would dictate kay employer na, oh Mr. Employer, yung mga hindi naming kamiyembro, bawasan nyo ng sweldo. O ito lang yung oras na pwede sila magtrabaho. Or other conditions, bawal po yan. Okay? Kasi, mapipressure ngayon si employer na, sige, sasama na lang ako dito kay labor organization na ito kasi malakas siya kay employer. Okay? Hindi po pwede yan. Next one, to dismiss, discharge, or otherwise prejudice or terminate, discriminate against an employee for having given or about to give a testimony. Testimony against whom? Testimony against the employer. Bawal din po na i-terminate ni employer yung mga empleyado na magrereklamo laban sa kanya in the proper forum sa mga korte. Kasi magiging advantage niya ito eh. Diba? So hindi po pwede yan. Hindi magiging willful yung pagbibigay ng testimonya. Or prejudicial po yung testimonya. Next one, to violate the duty to bargain collectively. Kapag ayaw makipag-bargain. Kasi meron pong duty, obligasyon si employer na makipag-bargain kay employee and vice versa, ganoon din. Si employee ay may obligasyon din na makipag-bargain kay employer. If the employer would refuse to bargain with the employee, yan, pwede po siyang kasuhan ng unfair labor practice. To pay negotiation or attorney's fee to the union or its officers or agents as part of settlement of any issue in collective bargaining or any other dispute. And lastly, to violate a collective bargaining agreement. Kapag meron siyang hindi nagawa, meron siyang hindi pinursu doon sa napag-usapan nilang stipulation sa collective bargaining agreement, that would amount to unfair labor practice. So, yung kanina po, siya po yung ULP ni employer. Ngayon po, unfair labor practice naman po committed by a labor organization. So, we have to restrain, coerce employees in the exercise of their right to self-organization. Okay. Bawal din po na pilitin ni employee, ni labor organization, yung mga manggagawa, yung mga employee, na sumama sa kanila. Okay, tandaan po ninyo kailangan po sariling desisyon ni employee yung pagsama sa labor organization. Yun po yung bottom line dun Free will. However, a labor organization shall have the right to prescribe its own rules with respect to acquisition and retention of members. Pwede pong gumawa ng policy si labor organization para ma-retain yung mga miyembro niya. B. To cause or attempt to cause an employer to discriminate against an employee, including discrimination against an employee with respect to whom membership in such organization has been denied, or to terminate an employee on the ground other than the usual terms and conditions under which membership is made available to other members. This is with regard to the house rules or membership rules in an organization. To violate the duty or refuse to bargain collectively with the employer, provided it is the representative of the employees. So again, I mentioned po na may obligation si employer. Same thing, may obligation din si employee or labor organization na makipag-bargain kay employer din naman. To cause or attempt to cause an employer to pay or deliver any money or other things of value in the nature of exaction for the services which were not performed or not to be performed, including the demand for fee for union negotiation, known as feather bedding po ito. Kapag sinabi exaction refers to blackmail, for example, to ask for money, doon sa mga bagay na hindi naman gagawin, not to be performed, So hindi po pwede na humingi si labor organization sa mga just to pressure the employer in giving in doon sa demands ni employee or ni labor organization. To ask or attempt to ask negotiations or attorney's fee from the employer as part of the settlement of any issue in collective bargaining or any other dispute. And lastly, to violate a collective bargaining agreement. So those are the actions which are considered as unfair labor practice on the part of a labor organization or labor group. Okay, what is a strike? Ano ba yung sinasabing strike? A strike occurs when a group of employees refuses to work. It is an effort to withhold employee services so that the employer will make greater concessions at the bargaining table. So, isa po itong paraan, para makompel, mapuwersa ni employee, si employer na sumunod sa kanila. What is being done in a strike? It is a temporary, okay? The word is temporary, temporary refusal to work. Hindi sila magtatrabaho. They will not perform their services to pressure the employer to respond doon sa claim nila. If the entire workforce of a company acts concertedly, kapag nagsama-sama sila, kapag may mass action and refuses to perform work, they can exert strong economic pressure against the company. So napakalakas na pwersa ito. Just imagine, in a company of 1,000 employees, for example, and 900 employees would go out and perform a strike. So, paano yung operation? Okay? Mawawala yung operation ng negosyo. Mawawala yung capacity to earn ni employer. So, this is a very strong economic pressure against the company. And also, it is a temporary action of a labor group to nudge the employer to succumb in their demand. Okay, para medyo, employer, sumunod ka sa amin. Kundi, mas magtatagal yung strike namin. So, siguro you would be asking, is strike legal or valid? There are instances where strike is considered valid. Also, there are certain actions, if committed, would make the strike illegal. Pag-aaralan pa natin yan doon sa next slides natin. What are the different types of strike? We have economic strike, unfair labor practice strike, jurisdictional strike, wildcat strike, sit-down strike, slow-down strike, recognition strike, sympathy strike. Okay. So, those are the different types of strike, no? Now, what is a lockdown naman? A lockdown is the cessation of business operation resorted by the employer. Sa employer naman ito to influence the employee to heed their terms. Kapag sinabing lockdown, hindi papapasukin ni employer yung mga employee na magtrabaho. Yung mga employee na ayaw sumunod sa kanya. Hindi sila pwede papasok. Ano yung magiging outcome nito kung hindi pumasok si employee? No work, no pay. So wala silang sweldo doon sa araw na yon. So malakas na pressure din ito sa part ni employer para makasunod niya si employee. What is picketing? It is an established form of strike to advertise the demands of employees and to discourage its employers to continue operation and immediately study their grievances to arrive at a favorable decision. It is the act of strikers to patrol back and forth, carrying placards or distributing literatures at the entrance of the company. Ito yung umiikot ng mga manggagawa. Okay? Umiikot yung manggagawa para magpwersa si employer na sumunod sa kanila. Sir, ano ba yung pwedeng, ano yung mangyayari kapag umikot na ng umikot yung mga manggagawa? It will cost attention. Attention saan? Attention sa mga tao outside. Diba? Their mindset is, oh, ba't ipipikit itong mga ito? Eh, may hawak silang placard. Kaya pala si ganitong company, ganyan pala yan. So, magkakaroon ng mindset na hindi maganda si company because there are individuals, there are employees na umiikot-ikot at nag-i-strike doon sa tapat sa harap ng company. And, one rule, yung tawag doon sa lugar kung saan sila umiikot-ikot is known as strike area. Strike area should be defined. Okay? Strike area should be defined. Kailangan malinaw kung saan yung area na yon. At hindi po pwede na kalat-kalat yung mga tao na nagpipiket. What is a boycott? It is an action to convince the employer to settle with the demands of the employees. This usually occurs when the customers are requested to sympathize with their claim and not to patronize the product of the employer. Normally, this is being done in supermarkets and grocery stores. Okay? Siguro may idea kayo kung anong supermarket yung kadalasan nag-boycott yung mga bagger, yung mga cashier, and other personnel. Ito. So, kapag nag-boycott, the boycotters or the employees who are on strike would tell the clients, would tell the customers na strike po kami dito eh. Please sympathize with our cause. Okay? Makasimpatya kayo doon sa hinaing namin. And ano yung magiging end result nito? What will happen is that the client or customers would not patronize, hindi sila bibili ng produkto ni employer. Ay, hindi pala maganda yung pakikitungo ni employer sa manggagawa niya. So, huwag natin bilhin yung kanyang products. Which would cause, again, andyan na naman yung saleability ng produkto ni employer. Decrease of sales na ayaw naman ni employer yan. What are the grounds for strike? We have 3 grounds for strike. Again, strikes being committed by the employees. First ground is economic strike or bargaining deadlock, fair labor practices, and union busting. Pag sinabi natin economic strike or bargaining deadlock, yan po yung hindi nag-meet. Ayaw mag-meet ni employer doon sa mga employees niya sa labor organization. Kapag sinabi ang fair labor practice sa kabilang banda, ito po yung mga action na binanggit natin kanina. Kung may ginawa si employer doon sa kahit na isa doon, that may be a ground for a strike. Ang union busting naman, dismissal of majority of the duly elected union officers, which would in effect cause dissolution. Kapag tinanggal, terminate yung majority ng union officer. Diba may mga opisyal, yung mga labor group or labor union. Kapag tinanggal yung mga yon, majority ng mga yon, madidissolve. Kasi hindi na kompleto yung mga officers niya. So, that would amount to union busting and maybe a ground for a strike. Now, what will happen if the strike is declared unlawful? Mamaya, in the next slides to come, i-enumerate natin kung ano ba yung mga unlawful na actions sa isang strike. Okay. If the strike is declared unlawful or illegal, it may cause the loss of employment of union officials. Tandaan nyo, it may cause the loss of employment union officials. Maaring matanggal sa trabaho. Okay. Pero may nakalagay dito, very glaring na who knowingly participate in that strike. Okay? Who knowingly participate in that strike. So, that term would connote na even if you are a union officer, pero hindi ka nag-participate doon sa strike. Okay? Wala kang ginawang unlawful na action. Therefore, it means na hindi ka madi-dismiss or hindi ka matatanggal sa pwesto. What the law says is that if you are a union officer and at the same time, you knowingly participate in that strike, then pwede kang matanggal. If on the occasion of the illegal strike, any union members who committed any unlawful acts or participated therein may lose their employment. So with regard to mga members naman, union members, kapag may ginawa silang aksyon which are prohibited, nagnakaw, nanakit, nanunog ng company equipment, then pwede silang matanggal. Pwede silang ma-terminate, ma-dismiss sa trabaho nila. Those who are members but did not participate in the illegal action, it does not automatically mean termination of status. So ito po yung sinasabi ko. You are a union member, pero hindi ka kasama doon sa mga nanunog. Hindi ka kasama doon sa mga nag-cause ng injury, nag-cause ng harm. Then, hindi po automatic na yung iyong estado as an employee may be removed from you. Employees are not entitled for back wages during the period of strike. So, habang nag-strike po yung mga manggagawa, of course, they are not working. Then, babalik na naman tayo sa no work, no salary scheme. Okay? No work, no pay. So, since nag-strike sila, wala silang back wage. Okay, that is very simple. However, if there is a return to work order pending proper decision or after assumption of jurisdiction by the President or by the Secretary of Labor and Employment, and that the employer refuses entry of these employees who are on strike, the economic strike would then be converted to unfair labor practice, and the employees therein shall be entitled back wages from the date the employees were refused entrance by the employer. So, paano ba yung scenario na ito? Okay. Isang kumpanya, Company A. The employees of Company A are on strike. So, the whole period na nag-strike, yung employees ng Company A, wala silang back wage kasi no work, no pay. Ngayon, meron ng order yung korte. Sabi ng korte, sige, balik na kayo mga employee. Ako na ang bahalang mag-decide kung sino ba sa inyo ni employer ang tama. Una yon. Pangalawa, sinabi ng Presidente ng Pilipinas na, okay, dahil vital yung trabaho nyo sa ekonomiya, balik na kayo sa trabaho ninyo. Mag-return to work na kayo. Or, pangatlo, Secretary of Labor and Employment ang nagsabi na, sige, ako na bahalang mag-decide niyan. Ako na bahalang mag-resolve niyan. Balik na kayong magtrabaho dahil vital sa ekonomiya yung trabaho nyo. So, ito manggagawa ngayon dahil mayroong return to work order. Papasok. Kung sinabi ni employer na sandali, ayaw ko kayong papasukin. Dahil ininis nyo ako, nag-welga kayo, nag-rally kayo, denied entry. Yan. From the moment dinenay ni employer yung entry, okay, magkakaroon po or entitled ng back wages si employees. What are the grounds for lockout? Magbibigay tayo. Ano yung grounds sa strike? Tatlo yun. Bargaining deadlock, or economic strike, unfair labor practice, and union busting. Now, what are the grounds for a lockout? Dalawa lang. Bargaining deadlock and unfair labor practice. Wala na pong union busting dito. So, ano nga yung mangyayari kapag illegal naman yung lockout ni employer? The employees in a declared illegal lockout are entitled reinstatement in their capacity and full back wages. Kapag sinabi ng gobyerno, ng proper forum, proper courts, na illegal yung lockout ni employer. So yung mga manggagawa na hindi pinapasok para magtrabaho, from the moment they are denied entry hanggang sa declaration na illegal yung lockout na yon, merong back pay. Okay? And ibabalik sila doon sa posisyon nila before na-deny yung kanilang entry. Now, dito na tayo. Ano ba yung bawal sa strike? Ano ba yung bawal na strike? Ano ba yung mga hindi pinapayagan na mag-strike? Okay? You have intra-union dispute, assumption of jurisdiction by the President or Secretary of the Department of Labor and Employment, after certification or submission of the labor dispute to compulsory or voluntary arbitration, when the issue of the strike is the same as that of the pending case, and then when the collective bargaining agreement has no strike, no lockout policy. So ito po yung mga bawal na strike. Ano? So, halimbawa, si Union A galit kay Union B, and then mag-strike sila. Wala namang kinalaman sa trabaho, di ba? So, what is the sense of going out and strike and having a strike? Wherein, hindi naman affected yung work na ginagawa nila. So, bawal mag-strike. Kapag sinabi ng Pangulo ng Pilipinas, as I mentioned a while ago, kapag sinabi rin ng Secretary ng DOLE, sige, ako na bahala mag-decide, mag-determine kung sino ba ang tama. Tama ba si employer? Tama ba si employee or labor organization? Balik na kayo sa trabaho nyo. And yet, nagpatuloy pa rin ng strike. Prohibited na po yun. Bawal na po yun. And kapag ibinigay na, nag-certify na sige, dali na lang natin sa voluntary arbitration yung kaso natin. Dali na lang natin yung kaso natin kay compulsory arbitration. And yet, nag-strike pa din. Si labor organization, bawal din. Or, meron ng mga sinaunang kaso of denial. Kapareho din naman ng mga issue, nag-strike pa din sila. Since habang dinidecide pa yung mga pending cases, dapat tuloy na sila magtrabaho. Kasi, upon resolution na yun magbibigay na ng decision doon sa mga case na yun. And for the employees not to go out and have a strike. Or, kapag yung collective bargaining mismo, may nakasaad doon na provision na walang strike, walang lockout. If that is approved by the employees, yung bargaining agreement na yun, na dapat sumunod doon, na hindi po pwede magkaroon ng strike or lockout. Under the case of po yan, ng Workers' Union versus Court of Industrial Relation. Okay. Kung titignan nyo, sa prohibited lockout naman, sa part naman ng employer, the same thing, ganun din. Kung ano ang ipinagbabawal, or kung ano ang bawal na strike, yun din yung bawal na lockout kay employer. Pareho lang sila. Ano yung mga actions na ipinagbabawal sa strike or lockout? Obstruction, interference by force, intimidation of any peaceful picketing. Kung merong, if there is a peaceful picketing, peaceful mass action, peaceful concerted gathering, or strike, at merong nag-cause ng gulo doon, and yung nag-cause ng gulo ay kayang i-trace kay employer, bawal po yan. Okay? Bawal po yan. Kaya nga, ang parati ko sinasabi sa mga labor organization, guard your ranks. Bantayan nyo yung mga tao nyo. Huwag kayo magpapasok ng mga hindi nyo kilala doon sa striker, sa mga kasamahan nyo. Kasi the moment may nakapasok doon, outsider, at mag-cause ng gulo, diba? Tendency, madideclare na illegal yung strike na yun. Kaya kailangan, kilala nila kung sino yung mga kasama nila. Another prohibited action is to employ strike breaker. It is the hiring of persons other than employees who are on strike to relieve the employer of possible economic loss, or to employ persons other than the employee who will cause injury or illegal action during the strike for it to be declared an illegal strike. Also, public officers, AFP, PNP, hired by the employer to escort replacement for strike. Kaya nga sabi, di ba, policemen should be outside the 50-meter radius. Yun ang parang sinasabi kapag may strike. So bawal po na mag-escort doon yung police, yung armed forces, public officers. Why? Ano po yung kinokos noon? It may create an impression wherein not tolerate ni PNP, ni AFP, ni public officer, yung mga ginagawa ni employer. Okay? Nag-create ng impression, nag-create ng stigma na pinapayagan naman pala nila na gano'n mali ang ginagawa ni employer. So, hindi pwede i-escort yung mga replacement, yung mga scab, yung mga papalit sa striker. To obstruct ingress and egress from the employer's premises and blocking thoroughfare. Sa part naman ng mga employee, hindi naman po pwede na nakaharang sila sa gate, hindi magpapapasok ng gustong magtrabaho. Kasi maaari mangyari na hindi lahat ng employee, they have the same sentiment. Some employees, okay sa kanila, na gano'n yung magiging terms, iba naman ayaw. So, hindi po pwede na i-obstruct. Pigilan ang mga employees gusto magtrabaho or lumabas doon sa kumpanya. Okay, so hopefully we had an idea of the unit that we just had sa labor organization. Ang bottom line dito, very important ang isang labor organization. As long as their objective is legal, as long as their objective is licit, maganda yung magiging output nun. Pero the moment na pinasukan na siya ng hindi magandang purpose, hindi magandang objective, then sayang naman yung labor organization. Okay?